5 seconds to go. Start. Therefore, it is reasonable to assume that such omissions could have taken place. Moreover, the possibility of a few words being left out while writing a long report cannot be ignored, and hence the mistakes were considered bona fide. Rejecting the allegation that FIR is anti-timed, the High Court observed that after PW1 was treated in the hospital at 8:30 pm, he could go to the police station to lodge an FIR, and that there is nothing unnatural about it considering the nature of his injuries. The High Court examined the spot map as per which the hospital and the police station were in close proximity. The documentary evidence supported the statement of PW1 that he returned to the hospital for proper treatment and was discharged the next day at 9 am. The High Court was of the opinion that the approach adopted by the trial court in discarding the evidence of PW1 and PW2 was hyper-technical. At the outset, the place of occurrence and also the occurrence of the event were not doubted by the trial court. The evidence of PW1 and PW2 being injured witnesses cannot be discarded based on minor inconsistencies. The High Court examined each of the contradictions and inconsistencies found by the trial court and concluded that the same was drawn on a speculative premise. The High Court held that a perusal of above analysis made by the trial court appears to have been done over meticulously with lot of guesswork made on this part. In this context, the High Court relied on the decision of the Supreme Court in the case of State of UP versus Gokran and others. In this case, Supreme Court had interfered with the order of acquittal by the High Court, stating that it becomes the duty of the court to interfere with the acquittal in order to redeem the course of justice. The High Court has adopted a hyper-technical approach to the entire prosecution case, reversing the finding of the trial court based on the evidence of DW1, Executive Engineer Electricity Distribution Division, Hamirpur, suggesting that there was no power during the time of occurrence of the incident. The High Court held that even according to DW1, he was not sure as to which phase the electricity connection to the Subhas market was connected. Yet again, the High Court felt that the trial court judgment is based on surmises and conjectures, particularly when there were direct injured eyewitnesses. On the question of contradictions in the statements of PW1 and PW2 with regard to their position and injuries sustained, it was held that the trial court was incorrect in discarding their testimonies, as in a situation of indiscriminate firings, it becomes very difficult for any witness to recollect as to who exactly was shooting at whom and from which exact direction. It was also observed that it is too much to expect an injured witness to depose distinctly about each and every injury received by the deceased and other injured persons. The High Court went on to observe that the trial court paid more attention to ascertain as to which particular injury was caused in what sitting position to the injured and the deceased rather than looking at the incident as a whole. The findings of the trial court doubting the presence of the witness on technical grounds was not accepted by the High Court. While considering the conduct of PW1 right after the incident, the High Court did not find anything unnatural. PW2 was asked to look after the injured children Vipul and Chandan, and hence he went home, and this is completely natural. The High Court rejected the findings of the trial court with respect to the fax message sent by the Superintendent of Police mentioning the arrest of Sahab Singh with a 0.315 bore rifle, as opposed to the recovery memo which mentioned 8 into 60 bore rifle recovered from Sahab Singh. Non-examination of a public witness during the arrest and recoveries. The search made during the arrest of the accused for the following reasons. The High Court came to the conclusion that the trial court erred in arriving at the decision that there was no recovery made from Sahab Singh on the basis of the fax message. The High Court found that the conclusions of the trial court were perverse, as the 0.315 bore rifle in the continental system having measurements R in millimeters is nothing but an 8 into 60 bore rifle. In the case of State of Uttar Pradesh versus Kishan Pal and others, it was held that the motive may be considered as a circumstance which is relevant for assessing the evidence, but if the evidence is clear and unambiguous and the circumstances prove the guilt of the accused, the same is not weakened even if the motive is not a very strong one. It is also settled law that the motive loses all its importance in a case where direct evidence of eyewitnesses is available, because even if there may be a very strong motive for the accused persons to commit a particular crime, they cannot be convicted if the evidence of eyewitnesses is not convincing. Stop.